Hello and welcome to today's video. A few weeks ago, I shared a video or I talked about how to register a company in Nigeria, and in that video, I provided the requirements and the procedures for registering a company in Nigeria. And in that video, someone left a comment requesting that we throw more light on a company shares or the shares of a company. And so in today's video, we're going to be talking about company shares. For this session, I have curated the list of frequently asked questions that we get when it comes to the subject of shares, and it is my desire that after you watch this video, you should be able to have the basic understanding of the subject matter of shares for people that are about to set up their company in Nigeria. Right, so let's dive right into it. What is a company share? In simple terms, a company share has to do with the rights or obligations that a person acquires by reason of the unit or the portion of the share capital of a company that person acquires. So because that individual has maybe purchased or paid for a certain unit or amount of shares out of the total share capital of a company, the person who has paid for those shares acquires rights and obligations and liabilities by reason of that transaction. So the person who acquires shares is a shareholder, and so you are a shareholder of a company to the extent of the amount or unit of shares that you have purchased out of the total share capital portion of a company. Now let me give a practical example so that you can I can buttress my point. So let's say, for instance, a friend and yourself, you go to maybe an eatery or a restaurant to buy meat pie, and say meat pie is sold at 1,000 naira. You don't have 1,000 naira, and your friend does not have 1,000 naira, but both of you want that meat pie, and so you contribute 500 naira to buy that meat pie, and your friend contributes 500 naira to buy that meat pie, making a total of 1,000 naira, and you buy that meat pie. When you acquire the meat pie, or you have purchased the meat pie, are you going to turn your face away from the meat pie? Yeah, you can decide to do that, but you bought it because you were interested in the meat pie, right? So by virtue of the 500 naira contribution you have made in terms of purchasing that meat pie, you are a stakeholder, or will I say a shareholder, as it concerns the subject matter of how that meat pie is going to be shared. So because you have contributed 500 naira, of course you expect the meat pie to be shared equally, right? So that is the same analogy you can use to describe your rights and obligation when it comes to share. I hope I've been able to explain shares, in a simple manner. Now, who is qualified to be a shareholder? In Nigeria, anybody is qualified to be a shareholder, but there are certain exceptions. Number one, a person that is below 18 years cannot be a shareholder, except the company already has qualified at least 2 adults who are qualified shareholder in that company, right? So someone that is below 18 years cannot be a shareholder, except there are 2 persons who are eligible that are already shareholders in that company. Now, a person that has been declared to be an undischarged bankrupt is also not qualified to be a shareholder of the company. Also, persons of unsound mind, the persons that have been declared by a competent court in Nigeria or anywhere else as a person of unsound mind, is not qualified as a shareholder in the company. Also, a person who has been disqualified for being from being a director of a company because the person carried out fraudulent activities is also not qualified to be a shareholder of a company. So I've mentioned 4 persons or criteria or category of individuals that are not required to be a shareholder of a company. An undischarged bankrupt, a person that has been declared to be of unsound mind, a minor, that is someone that is below 18 years, except there are 2 competent adults who are shareholders in the company, and a person who has been disqualified from being a director of a company because the person has been convicted of fraud, right? Now, in Nigeria, we have types of shares. There are various types of shares, and I'm going to be listing them out, right? So we have the ordinary shares. Now, the ordinary shares is a very common and popular type of shares for companies in Nigeria. Now, people who hold ordinary shares, generally, they have voting rights, right? So that is for ordinary shares. But however, people who own ordinary shares in a company are usually the last to receive certain kinds of benefits within the company, and I would explain. We'll see that as we explain the other types of shares, right? We also have the preference shares. So like the word preference, right? That is where that type of share derives its meaning from. So a person who has this kind of share generally is entitled to certain kinds of preferential treatment in special cases, and I'll give examples. For instance, in a situation where the company wants to pay dividends, right, the preference shareholders are paid first, or a person who owns preference shares, that person will be paid dividend first. Or in a situation where the company is under financial crisis and still needs to fulfill its obligation of paying or compensating its shareholders, the people who own preference share, this type of shares, plus preference shares, will be paid first or compensated first before even the ordinary shareholders, the people who own ordinary shares, right? So you see that difference or distinction. Now we also have deferred shares. So for the deferred shares, like the name implies, deferred. So these people that own deferred shares, basically their rights are deferred to enable other shareholders, like the preference shareholders, to take until the rights of those other shareholders are satisfied before their own rights are being, or obligations are being, their own rights are being met, right? So that's what deferred shares is all about, right? We also have cumulative shares. So accumulate. So basically, for this kind of shareholders, when in a situation where a company is not able to declare or pay dividend within a financial year, the shares of the dividends of those of persons who own this kind of shares will accumulate into the time when the company is able to pay shares. So what that means is that their dividends are they accumulate. Dividends of this kind of shares or shareholders accumulate over time. So let's say, for instance, company A has a financial year, and in that financial year they did not declare dividend, right, or they did not pay dividend. That doesn't mean that in, maybe say in 2026, for instance, when they want to now pay dividend, that the one for 2025 goes away. No, they will still pay that of 2025 and that of 2026, right? So because, generally speaking, a company can decide, has a right to declare dividend or not. So it's not mandatory for every company to declare dividend. So, but in the event that the company now declares dividend, people who own cumulative shares, they will be entitled to receive dividend for both the year that dividend was paid and the year that dividend was not paid. I hope I've been able to explain that. And then the last type is redeemable shares, from the word redeem. So basically what that means is that owners of this kind of shares have the obligation to surrender those shares back to the company. In other words, the company has the right to redeem those shares by virtue of an agreement, of course, upon the satisfaction of certain conditions. So a company can decide to take back the shares that they gave to such persons, maybe at a particular point in time, or when certain conditions that are stated in an agreement happens or takes place. But of course, in practice, it is not feasible. Of course, people who own redeemable shares, people who own redeemable shares are not required to own that share alone. They don't own redeemable shares alone. So they own redeemable shares alongside maybe an ordinary share or preference share. I hope I've been able to explain the types of shares, right? So the next point, what are the rights of shareholders? Of course, if you own a stake, right, or you own rights, like we said, you own rights you are entitled to rights and also entitled to liabilities and obligations in a company by virtue of being a shareholder. So what are the rights of shareholders? As a shareholder, you have a right to vote, you have a right to attend meetings, you have a right to be paid dividend when it's declared, right? You also have a right to be issued a statement of the financial records or the books, statutory books of a company. You have a right to inspect the statutory books of a company, and you also have preemptive rights. There's what you call preemptive rights of shareholders. Now, preemptive rights of shareholders simply means the company will not sell shares, for instance, to an outsider or a person who is not a shareholder without first offering you, who is an insider or a shareholder, to buy. So that's a preemptive right. So if whenever the company is considering selling shares to the public, they will first of all, especially for public companies, right, they will first of all consider the insiders who are already shareholders and ask them, CEO, we are offering these shares, do you want to buy? And if they say we want to buy, you finish buying first before they now issue to outsiders what is left, or you buy at a reduced amount and then they issue to outsiders at a different amount. So those are the benefits and the rights that shareholders are generally entitled to. Now, do shareholders get paid for owning shares? Of course, every shareholder, especially in a public company, is required to be paid. They pay dividends, right? So that payment is what you call dividend. But of course, like I said, it is not mandatory for a public company to declare dividend every year. They can decide to declare, and they may decide not to declare. For private companies are not obligated to declare dividends, right? Because they raise funds in-house. They don't raise it in the public. But if you're a shareholder in a company, somehow you are entitled to some form of compensation by reason of your contribution towards the capital of that company, right? So now, how many shares is my company expected to have for a start? Now, my answer to that is it depends. There are several factors. So, for instance, you need to ask questions like, what is the nature of business of that company? So there are certain kinds of businesses that are regulated. For instance, the maritime sector is regulated by various organizations and bodies. You have the NIMASA, there are many organizations that register that, and the share capital requirement for that, minimum share capital requirement for that is 25 million shares, right? If you want to operate a travel and tour company, for instance, the travel and tour company is regulated by the Nigerian Civil Aviation Authority, right, amongst other bodies. And one of the minimum share capital requirement for operating a travel and tour company is 30 million shares. And I could go on and on. So I would say, if you're starting a company and you need to know about it, find out from trusted experts, a legal professional, to be sure about the minimum share capital requirements of your sector. So you need to confirm if that sector is regulated, and then maybe is there any regulation as to the share capital requirements, because you need to satisfy that, especially where those sectors requires licensing right after registration. So another factor that determines the share capital of a company is the members. So for instance, are the members of the company, whether directors or shareholders, are they foreigners? Of course, you know that currently for obtaining expatriate quota, the minimum share capital requirement for that is 100 million shares. So once you're a foreigner, so long as you are not a Nigerian, even if you're a Ghanaian or you're from Zimbabwe or you're from the United States or wherever, so long as you have a foreign passport that is not a Nigerian ID card, you are a foreigner. And if your name is going to be, if you're going to be a member of that company, either as a director or a shareholder, the minimum share capital of that company is going to be 100 million shares. Right? I explained that extensively in my previous video, how to register a company in Nigeria. You can check that out on our page and go watch it at your convenience. Another factor that determines the amount of shares that your company should start with for a start is whether that company has intentions of raising funds through equity, right? So when you're trying to raise funds for a company, there are two options, either through debt or through equity. By equity, I mean, so someone gives you money in exchange for certain amounts of shares, right? So the person is contributing to the company in exchange for ownership rights, right, and benefits in that company. So if you have such intentions from the onset, especially startups, they are mostly the ones that they are the types of companies that usually consider equity fundraising, right? So if you are considering that, that will also determine the amount of shares that you need to start with when forming your company. In all, I would say, please, this is where an expert comes in. This is where a corporate lawyer comes in. Please get expert legal advice, especially with regards to your capital or share capital structuring when you're about to start your company, right? So that you don't have issues along the way. Now, the next thing is, how do I have to pay every amount contained in my statement of share capital during registration, right? So when you're registering a company, there is a portion of your company documents that has statement of authorized share capital. Now, sometimes, like I said, let's go back to the examples I gave. Let's say you're registering a travel and tours company and the minimum share capital is 30 million, right? Now, does that mean that you're going to pay 30 million naira while you're registering the company? The answer is no. You will not pay 30 million naira. However, you will be paid based on the assessed amount that is calculated, and the assessed amount is usually dependent on the amount of shares that is stipulated. So if you say you're registering for 30 million naira, there is a calculation. For instance, there is a stamp duty rate for that amount of shares. There is also the company registration fees for that amount of shares, right? So you only pay the assessed amount, but you will not be required to pay 30 million naira at least, right, when you're registering your company. Now, however, there are some situations where you would actually be required to put out that amount. One particular sector that I will not fail to mention is the banking sector. So let's say, for instance, you want to set up a microfinance bank or a commercial bank. Of course, there are minimum share capital requirements for that. For instance, the unit tier 2 microfinance bank, the share capital requirement is 50 million. Now, for the purpose of getting license for the bank, a bank license for that kind of microfinance bank, the CBN says that you're going to deposit that 50 million naira into an escrow account, right? So for the purpose of licensing, there are situations where you may be required to either provide a fidelity bond, as regards that amount of shares, or you might be required to deposit that particular amount. But when it comes to the registration, right, registering the company with the Corporate Affairs Commission, you will not be required to drop or pay that particular amount of shares. So I just thought to also clarify on that. Okay, so the next question is, okay, so shareholders agreement, right? You can't talk about shares without talking about the shareholders agreement. And what is a shareholders agreement? The shareholders agreement is simply a document that defines the rights and obligations of shareholders within a company, as well as the obligations of those shareholders to the company. So it's a contract between shareholder and shareholder, that's themselves, and all the shareholders and the company, right? Now, why is a shareholders agreement important? Now, generally speaking, when you're forming your company, you have what you call the memorandum and articles of association of the company. That document simply defines laws, rules, and regulations as to how the company operates, of course, and how members operate among themselves. But if you're considering the issue of having a shareholders agreement, despite the memorandum and articles of association, it's very, very important that you have that shareholders agreement for various reasons. Number one, the memorandum and article of association of a company does not explain in detail, it does not make provision for several things, several activities or events that will occur as far as that shareholder relationship versus company shareholder relationship will exist, right? Number two, shareholders agreements are very flexible and you can always amend them without the procedure of trying to file for consent, apply for this, apply for that at the corporate registry. If you want to, for instance, amend your memorandum and articles of association, there are so many procedures you have to go to. First of all, the company must file annual returns up to date, a board resolution must be signed, must be made, giving consent, and then the specific details of the changes made would have to also be done. So it's a very, very rigid procedure. Whereas in a shareholders agreement, amendments can be made and without so much rigidity or rules or conditions attached to that amendment, right? Also, the contents of a shareholder agreement are confidential because, of course, the agreement is only made between two parties, right? And so it is confidential and kept within the parties involved. This is unlike the case of a memorandum and articles of association that's a public document. So if an outsider wants to know the laws governing that company, they just go and apply for it, and you have access to the memorandum and articles of association of the company. So if you need an extensive document, a document that covers as much as possible every issue or every event that is likely to occur within a company as far as shareholders are concerned, it's important that apart from getting the normal registration documents, which includes your memorandum and article of association, please try and make efforts to get a shareholders agreement, especially when you're starting a company for serious business, and especially where you're dealing with third parties, or will I say people that you're not familiar with, you're dealing with strangers and money is involved, huge capital is involved. You need to have a shareholders agreement. It will address areas that are not covered in your memorandum and articles of association, and it's to a large extent it will keep certain information confidential, right? Now, why is a shareholders agreement important, or what are the we've explained why a shareholders agreement is important. Now, what are the matters that are addressed in a shareholders agreement? I'm just going to be mentioning some of them. For instance, a shareholders agreement addresses issues like what happens in a situation where a shareholder wants to sell his shares to an outsider, a person who is not a member of that company. A shareholders agreement will address that issue, right? Also, it will address issues like how will subsequent capital be raised by the company. It will also address situations where a shareholder who already has access to the trade secret or confidential information of the company wishes to set up their own similar company or set up a competing company. You know that there are situations where a shareholder is a member of a company. Of course, you'll be privy to certain sensitive and private information of a business. So in a situation where that shareholder who has access to that kind of information wants to go and set up their own company, what measures will be put in place to protect the company's trade secret, right? A shareholders agreement will cover that. And also, and very importantly, in a situation where a dispute arises between shareholders or even the shareholders and a company, what measures will be taken to resolve those disputes? So these, among many other points that I've not raised in this video for want of time, are factors that are usually addressed, or matters that are usually addressed in a comprehensive shareholders agreement. And so that's why it's very important, after dealing with the issue of the share structure and the share capital of your newly formed company, it's important that you take adequate steps to also get a shareholders agreement amongst your founders. I hope you found this video very useful, and if you have questions that you need to ask either from this video or any other legal subject matter as it concerns law and business, feel free to leave them in the comment section. If you also need advice with regards to the share capital restructuring of your company, allotting shares within members of your company, and even you need guidance or assistance with professional assistance with preparing a comprehensive shareholders agreement, feel free to reach out to us through the contact information that will be provided in this video, or through the contact information is also in the description section of our YouTube page, and we will be delighted to respond to you. Until I come your way again, please do me a favor, share this video, like, comment on it, and you can also make recommendations on what topics you want us to also talk about, right? And until I come your way again, bye for now.